My name is Gregory Tendrich. I have a law firm in Boca Raton, Florida. My practice is devoted exclusively to securities-related cases. I represent investors with claims against their financial advisors and stockbrokers. I also have a side of my practice where I represent brokers with claims against their current employers or former employers, claims involving promissory notes, forgivable loans, transition packages, anything involving their employment, as well as their termination from their employer. My background includes spending 10 years as an in-house lawyer for two very well-known large stock brokerage firms, Wachovia Securities and First Union Securities, as well as some small broker-dealers in the Boca Raton, Florida area. As in-house counsel, I represented the firm in all securities claims that were brought by customers against the firm, as well as representing the firm in matters involving compliance and regulatory enforcement. In a typical promissory note claim, a broker can raise a number of affirmative defenses, which are reasons why he may not be required to pay either a portion or all of the promissory note. In all of these cases, you look at whether or not the terms of the promissory note are unconscionable. And when I say unconscionable, I mean are the terms don't meet your typical standards of good faith. The payments are usurious, are overbearing, or if the employment contract that has been offered by the broker involves having the broker engage in unethical practices. That may be a reason or an affirmative defense to a broker promissory note claim. There's also the issue of whether or not the firm acted in good faith, or typically we call that was bad faith involved. Bad faith means that the brokerage firm may have made promises that they couldn't keep, or they engaged in underhanded dealings with you that could void the claim and you having to repay that claim. Another affirmative defense is something called accord and satisfaction. Accord and satisfaction could be that you have actually satisfied the terms of the promissory note, and accordingly the firm is barred from pursuing its claim. If you believe that you have satisfied all of the terms and conditions under the loan, have made all of the repayments under the loan, the firm could not pursue that claim, and that would be an affirmative defense as well. I had mentioned earlier acting in bad faith. Unclean hands is the legal term to describe the conduct of a brokerage firm moving to seek enforcement of a promissory note when it's their very conduct that may have forced you to leave or created a reason why there should not be a repayment on that promissory note. All cases are different, and that's why it's so important to speak to a lawyer about whether or not there are other potential defenses in these cases, and it's always good to sit down with a lawyer prior to filing that answer and come up with a strategy for what, in fact, your viable affirmative defenses may be. Thanks for watching our video today. If you'd like more information about me or my law firm, you can visit us on our website, www.yourstocklawyer.com, or you can call our law firm at 561-327-7782. We look forward to hearing from you, and we offer a free initial consultation. Thank you.